Hi, welcome to Central Texas College Equal Employment Opportunity and Sexual Harassment Prevention Training. I'm Scott Wyman, the Training and Technology Coordinator here at Central Texas College, and I will be your instructor for this course. If this is your first time taking this course, welcome to Central Texas College. It's good to have you here. This is your second or subsequent time, welcome back. So this course is good for either initial EEO SHP or 2-year EEO SHP. So as you can tell, if you're new, you're going to have to do this again in 2 years. That's kind of a state requirement. So CTC put it in their policy to also make it a 2-year requirement. So I broke this course down into 2 separate sections. Part 1 is going to be the Equal Employment Opportunity section. So this is where we'll get into discrimination and harassment, not sexual harassment. Sexual harassment, sexual assault is going to be part 2. Okay, so somewhere hidden in one of these 2 courses is going to be the pass key that you're going to need to submit the training completion form for this course. You can watch this video as many times as you want to, but until we get that training completion form, we're going to assume, and yes, I can do that for this, we're going to assume that you haven't done it yet. So make sure you pay attention going through this course and the next course. When you see that pass key, make sure you write it down. After you've finished watching the second video, go into eTrieve, search for EEO, and you'll find the EEO completion form. It should auto-populate with your name and ID number, so all you'll have to do is put in that pass key. Click the submit button, and off it will go to our office. All right, so here's our objectives for this first part of the course, for the discrimination and harassment part of it. First of all, I want to increase your understanding of CTCD's policies and procedures relating to employment discrimination and harassment. So we have the policies in place. We have laws in place. So we're gonna talk about both of those. Okay, so they both apply. And we're going to look at most of this course, this first half of the course, I have to admit, is going to be talking about discrimination, equal employment opportunity discrimination, to be more specific. But I'll try and throw in harassment as well, because harassment happens a lot more than you may think. Okay, so we'll get into the differences between discrimination and harassment here in just a few minutes. Number 2, I want to provide a forum where we can discuss expected workplace behaviors. Now, naturally, you're not sitting in front of me in a classroom. You can't just say, hey, Scott, what about this while you're watching my video? But you can send me an email. You can give me a call. I'll give you my email and phone number right here. So just jot down any questions you may have going through this. And please, if you see any mistakes, let me know, and I'll be more than glad to go in and correct any mistakes that have been made. And number 3 here, if you want more information, there's a couple of different places you can go. My go-to spot for questions when I'm looking for answers is the EEOC, that's the Equal Employment Opportunity Commission in Washington, D.C. Their website is www.eeoc.gov. And we'll be taking a look at part of their web page here in just a little bit. Another place you can go is CTC's faculty and staff page, more specifically the Human Resources Policies and Procedures Manual. By now, you should have been out there and perused at least a few of our policies. If not, I highly recommend you go out to the website and you review our policies so that you know which ones apply to you, which ones are important to you. They should all be important to you if they apply to you. Okay? Not all of them are going to apply to everybody. If you're full-time, well, then the policies that apply to part-timers don't apply to you, so why bother? unless you're a supervisor. If you're a supervisor, then you may want to look at all of the policies so that you can be familiar. That way, if you have full-time, part-time, faculty, and staff all working for you, you know what the policies are, okay? All right, so let me just start with some numbers. I use this to simply show why this course is so important, why we teach this course, why the state wants you to have it every 2 years. This is a list of complaints filed nationwide with the EEOC up in Washington, D.C. So I go back to 2011 and I got it all the way up to 2022. They don't have the numbers out for 2023 yet. But these numbers come from the EEOC's website. And let me just show you real quick here if I can dig it up. There we go. This is the EEOC's website, right? www.eeoc.gov. And then I searched for charge statistics. So out here on this web page, they have charge statistics broken down by category. This top line is total charges, all the way from 1997. Okay, so here in 1997, you can see that 80,680 complaints were filed with the EEOC. And then you can just look across there and see how things have changed over the years. And like I said, it goes all the way up. The most current year is 2022. Okay, so 2022, the EEOC had 73,485 complaints filed with their office. Geez, that's a lot of complaints, isn't it? And then here's the breakdown. It breaks it down by race. 20,000, almost 21,000 based on race, 19,000 based on sex, 13,000 based on religion. The number one, the most complaints filed has been with disability, 25,004 complaints this year. All right, I'm not going to go through all the different categories there. You can refer to that page if you want to. But I do want you to know that 2011 was the highest number of complaints filed with the EEOC to date. All right, 99,947 complaints filed in 2011. Wow. The lowest number of complaints filed with the EEOC to date was 2021. And I'm not sure, but I would guess, don't take this as the truth or the gospel, but I would guess it has something to do with COVID. Even if there was only one complaint filed with the EEOC, that's one complaint too many. All right, last year there were 73,485 people who felt like they were being treated unfairly for one reason or another at work. We need to do our part to make sure that we are not part of that list. Granted, CTC has its issues. Here's a list of complaints filed here at CTC. 2015, we had 22 complaints. In 2016, it dropped down to 18. 2017, I'm not sure what happened in 2017, but it jumped all the way up to 60 complaints. 2018, a significant drop down to 28. 2019, there were 18. 2020, there were 8, and then we move on to 21, 22, 6, and 7. Again, I would guess that has something to do with COVID. Now, I'm not going to go through all of these. One that sticks out in my mind here was 2018. And 2018 really struck a bell because of these 28 complaints that were filed, 2 were based on any of the protected categories. 2 were actual EEO complaints. The other 26 had nothing to do with race, religion, sex, color, national origin, age, or disability. Understand that every complaint that is filed with Jackie Thomas's office and our EEO office here in HR, she has to investigate it to protect CTC and its employees, because you just never know what underlying agendas might be in some things. But she's investigated all kinds of different complaints from actual race and age discrimination. We've had sexual harassment complaints, not a lot, but we've had a couple. To things like somebody filed a complaint once because a coworker threw their trash in their trash can. Somebody saw a coworker sitting in their vehicle before work. Jackie had to investigate those. Okay, so I encourage you now that, well, after we're done with this, you're going to know what constitutes an EEO complaint. If it's not based on EEO issues, take it to your supervisor. Our EEO office, Jackie Thomas, should not be used as a tool or a threat, which I've seen that. People will say, you know, hey, if you don't stop doing that, I'll report you to Jackie. Well, fine, go report to Jackie if it's an EEO complaint. If it's not EEO complaint, go to your supervisor. All right, moving on. Bottom line is this EEO compliance, it applies to everybody. I don't care who you are, I don't care what your job is, and I don't care who you think you are because of what your job is. These policies apply to everyone. All right, we've got two definitions we're going to talk about for this part of the course. Number one is unlawful employment discrimination. It's important that you understand exactly what unlawful employment discrimination is, because discrimination in and itself isn't always unlawful. But if it meets this definition, if it's a behavior that occurs when employment decisions are based on any of the protected categories under state or federal law. Two key parts to this. Number one, it must involve an employment decision. Think about all the things you do at work that are work-related. If you're denied access to any of those particular things, and it's based on a protected category, we're going to talk about the protected categories here in just a little bit, then it meets this definition. If it's based on a protected category but doesn't involve an employment decision, then it's not unlawful employment discrimination. If it's an employment decision but it's not based on a protected category, then it's not unlawful employment discrimination. Make sense? Good. The second definition is unlawful harassment. Again, we word it like this because harassment in and itself is not unlawful. In order to be unlawful, it must be repeated, unwelcome, and offensive slurs, jokes, or other oral, written, graphic, or physical conduct relating to any of the protected categories under state or federal law. So there's actually three parts to this definition that are key and must be met before it can be considered unlawful harassment. Number one, it must be repeated. A single isolated incident does not make unlawful harassment. Is it appropriate for the workplace? Probably not. Is it professional? Probably not. So for those two reasons are enough for you to take that situation to your supervisor and say, hey, boss, let me tell you what's happening. Number two is it must be unwelcome. Well, if I'm a harasser, how do I know what I'm getting ready to do is unwelcome or not? Should I ask the person? Should I do it and see what kind of reaction I get? No. If the other person, here's what you do. Think about it this way. If the other person doesn't ask for it, then assume that it's unwelcome. And yes, in that situation, I gave you permission to assume. So if you got a really good religious joke or a really good racial joke or a really good sexual joke, whatever the case may be, if the other person doesn't ask you to tell them that joke, then don't. And if the other person does ask, then they're inviting that bad behavior And in that situation, you're both subject to the policies, okay? So even if they ask for it, if it's unprofessional, don't do it at work. Easy enough? Good. All right, we have federal laws. I've mentioned state and federal laws. So we're going to talk about a few of the federal laws, and then we'll roll those into how they apply as far as the state laws. But the federal laws are in place to protect all of us. They prohibit employment discrimination against any of us and all of us. It doesn't matter what classification you are. You meet one of the protected categories, or more, most likely. So these laws are in place to protect you. CTC's policies are in place to protect all employees, not just a few. So these laws cover personnel decisions that could affect employees or applicants' employment opportunities. So those folks out there filling out an online application, they're protected against unlawful employment discrimination and harassment just like you are. So the first of the federal laws we're going to talk about is the Civil Rights Act of 1964. And naturally, it's been amended. Most of our laws have been amended at some point in time. But the Civil Rights Act ended segregation in public places. That was huge. The second thing it did is it banned employment discrimination on the basis of race, religion, sex, color, and national origin. That's what I call the Big Five. Race, religion, sex, color, and national origin. We'll talk about each of these categories, not in detail, but you need to have an understanding of exactly what they are, what they entail. So race discrimination is fairly simple to understand. It's discrimination that includes treating someone unfavorably on the basis of something that identifies them as a particular race, whether it's the shape of their eyes, the texture of their hair, the size and width of their nose, these different things that people can look at you and classify you as a particular race. Make sense? Okay, I'm not going to define race because there are probably 100 different definitions of race out there. So just look at it like this. If you're being treated unfairly based on something that ties you to a specific cultural characteristic or something that may identify you as being part of a specific culture, then that could be considered unlawful, whether it's discrimination or harassment. Okay? So that's race. I just mentioned some of the characteristics. Just try and think about some other characteristics that may help identify a person to a specific culture. Okay? All right. Religion. Religion is huge, folks. Religious discrimination involves treating a person unfavorably because of his or her religious beliefs or a lack thereof. Doesn't matter which god or goddess or gods and goddesses that you pay homage to, or maybe you have no religious beliefs at all. My best advice when it comes to religion at work, if you're going to open your mouth and talk about religion, you first need to open your mind, because you never know which one of these is going to be in the cubicle next to you or in the office across the hall. We don't forbid people from discussing religion at work, but we don't encourage it either, because it is such a deeply held belief system. Okay, and that's exactly what it is. It's a belief system. Do we all believe the same thing? No. Of course, we don't all believe the same thing. We're individuals. Even people within the same general religion. Okay, Christians, for example. Think about how many different religions there are under the Christianity title. Baptists and Methodists and Catholics. I mean, the list goes on and on. Mormons. Okay, those are all Christians. So just think. Think before you speak. Because again, you never know who might be beside you. And just because you're not speaking directly to a person, if they hear you or see you doing something that offends them, you could be finding yourself on the wrong side of a complaint. Okay, and we don't want that. We don't want that. So think before you speak. Respect everyone, no matter what their religion is. And remember, if you're going to ask them about their religion, you better be willing to listen to what they have to say, even if it's totally against what you believe. You asked, okay? Now, also regarding religion, the law provides that employers must provide religious accommodation as long as it doesn't create undue hardship on the employer. Best thing to do, ask, okay? Ask your supervisor, hey, I need some time off this period of time. I need to go find myself at a religious retreat, or I need to go make peace with this, or I need to go meditate that, or I need to go do whatever. But let them know why. And then that leave request should override other people's general leave request. But also that this isn't free time. You have to take vacation. You'll be charged leave for this time off. Questions, comments? No? Okay, good. Moving on then. All right, so that's race and religion. Now we have sex. Sex and gender fall under the same category. Gender is I guess you could say, a subcategory of sex. Right? So treating someone unfavorably because of that person's sex, including that person's sexual orientation, gender identity, or pregnancy. All of these categories are protected under state and federal law and CTC policy, by the way. So to break it down just a little bit, so male and female, those are our biological parts, okay? Those are biological parts. Gender, you have masculine and feminine. Gender is used to describe characteristics of a woman and a man that are socially constructed. Okay, it's a social thing. Men should be like this and women should be like this. But if you have a man who's like this, well, now you have kind of a cross. So you have a man with feminine characteristics or a woman with masculine characteristics that crosses over. And a lot of people don't think that crossover should happen. But it's not for you to decide how that person should be. We should just accept them. Okay? Three words that I like to live by: tolerance, acceptance, and understanding. Tolerate different behavior. Okay? Don't tolerate bad behavior, unlawful behavior, unprofessional behavior. But just because someone's different than you doesn't mean they're wrong. It simply means they're different. Imagine what life would be like if we were all the same. If we were all the same, there would be no invention, because there would never be any thought outside of what you're already thinking. Right? Innovation drives invention. And if you think about all the different people around you, each of those different people have different ideas, different beliefs, different values. And we can learn a lot from them. So, tolerate different behavior. Accept others for who they are, not who you think they should be. Again, we're all different. So accept them for who they are, not who you think they should be. And seek to understand why they do the things they do. Why does that person behave differently? But again, you have to be careful when you start talking to people about your beliefs and values and thought processes. Because when they start explaining to you why they do the things they do, you have to be willing to accept that. Even if it's just during the conversation, accept what they're saying as their beliefs and values, not yours. Because we can agree to disagree. I know it's an old cliche, but we can agree to disagree. Color is the next of the protected categories. Color simply refers to the color of your skin, no more, no less. It's not the same thing as race. It's not the same thing as national origin. These are separate categories because people of the same race can have different skin color. They can be lighter skinned or darker skinned. And some people have been known to use that as a basis of treatment. Hopefully none of us ever would. But the possibility is there, so you need to understand it, okay? National origin is the last of the 5 protected categories listed under Title VII of the Civil Rights Act of 1964. National origin is an individual's place of birth. That's for first-generation immigrants. If you're second or subsequent generation immigrant, then it's your family's country of origin, right? What country does your family originate in? Did your family, maybe your mother came from Turkey and your father came from Japan? That's your national origin. All right, here's your first lesson on how to report violations of CTC policy and laws, right? I'm going to say CTC policy because CTC policy covers everything that the state and federal laws do. The first thing you need to do when you witness or when you're the victim of unprofessional, inappropriate behavior is document it. Document, document, document. Who, what, when, where, why, and how it made you feel. There's an old saying that pretty much holds true. If it's not documented, it never happened. So document these things. On this day at this time, this person said this to me. Or on this day at this time, I overheard this person say this to another person. Different ways to document these things. You can write it down on a piece of paper. You can jot it down in a notepad on your phone or your computer. You could send yourself a text. That's a really good way to do it. Send yourself a text. That way you have a date timestamp on it. Or you could send an email. Send an email to yourself. Okay? Document, document, document. Because what you want to do, remember, a single isolated incident does not make harassment. It may make unlawful discrimination, but either way, you need to document it. That way, if it happens again, now we have a behavioral pattern, a paper trail. So after you've documented it, now you need to report the bad behavior, whether it's discrimination or harassment, or maybe it's just unprofessional. The first and best place to go is the individual who did the bad behavior. Right? Go to the source. Say, hey, fellow employee, I heard you say this and it really offended me, and I would appreciate it if you didn't say it anymore. And then you document that you reported it. including anything that they say in return. Hopefully they would be gracious to this information, say, oh, I'm very sorry. I didn't even realize I said that. I'll do my very best never to say it again. Document that. Or they may tell you to take a hike because they'll do whatever they want to do. You're not their boss. Document that. And then if the bad behavior happens again, document it. If you're not comfortable going to the person who did the bad behavior, because not everybody's comfortable with that, that's okay. You don't have to go to that person. It's just encouraged. But if you're not comfortable with that, you can report that bad behavior to your supervisor. If you're not comfortable reporting it to the supervisor, or maybe your supervisor is the problem, then you can go straight to the EEO office here in HR. But again, EEO related, race, religion, sex, color, national origin, one of those 5. Is it based on one of those 5 categories? Was it repeated? Was it unwelcome? Right? That's the harassment side of it. Was it based on a protected category, and did it involve an employment decision? That would make it what? Yes, unlawful employment discrimination. So those are the things that you need to be taking to EEO if it doesn't stop. If it's not based on any of the protected categories, then go to your supervisor. And then number 3 is repeat steps 1 and 2 as necessary. Like I said, you document it, you report it to the individual. If it happens again, you document it. Who, what, when, where, why, and how it made you feel. How it made you feel is the key in this. It made me feel uncomfortable. It made me feel threatened. It made me feel whatever, uneasy. Document, document, document. Report it. If you went to the individual the first time, don't go back to the individual, because they're not going to listen to you any more this time than they did the first time. This time you go to your supervisor. Say, hey, supervisor, this is the second time this type of incident occurred. Here's the documentation. After the first time, I asked the individual not to do it or say it anymore, and they said, okay, I won't. But it just happened again. The supervisor should take that information, call Jackie Thomas and let her know what's going on, and then that situation will be investigated. Hopefully, after the situation has been investigated, appropriate action will be taken. What action is taken is none of your business. But appropriate action should be taken. If it happens again, document, 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 and report it. Go back to your supervisor. Hey, it is happening again. If it happens a third time, right? First time you went to the individual, second 2 times you went to the supervisor, and if that bad behavior is still happening, obviously what your supervisor is doing isn't effective. So now you're going to go to your supervisor's supervisor and say, hey, this is the 4th time this has happened. First time I went to the individual, second 2 times I went to my supervisor, but that bad behavior is still happening. Don't automatically assume that your supervisor is not doing what he or she is supposed to. That's what your supervisor's supervisor or Jackie Thomas will find out if that's the route you prefer to take. All right, so that's reporting. It's important that you do this correctly. If you report it once and the person doesn't get fired like you expected that to happen, don't just give up and say the system doesn't work. Because we have a progressive disciplinary policy. It should be a verbal warning, then a written warning, then another written warning that goes in their permanent file. Then they can go to suspension with or without pay. They can go to demotion, and then last and final resort would be termination. But it would take a lot a lot of repeated bad behavior for termination, and it has to be documented. If there's no documentation and you say, well, this is like the 8th time this person's done this to me, they're going to say, where's your documentation? How do we know you're not just making this up because you don't like that person? Okay, document report, document report, document report, document report. The system works if you work the system. I know, because I used to be part of the system. All right, the EEOC in Washington, they're the folks who enforce Title VII of the Civil Rights Act of 1964. If a federal law is broken, then you can go to the EEOC to file your complaint. Okay, so if any of those 5 protected categories and involves employment discrimination or it's unwelcome and repeated, you can go to the EEOC if you want to. We recommend you go to Jackie first, work the system here at CTC. If that doesn't work, then you can go to the EEOC. But we would really rather not see that happen. Okay? We would rather not see that happen. So Title VII of the Civil Rights Act also prohibits retaliation. Retaliation is taking some sort of negative action against a person who opposes discrimination, something that may make them afraid to file another complaint or to file a complaint, because who's protected against retaliation? Well, the employee who opposes the discrimination, a person assisting in the investigation, which means the investigator, the complainant, the alleged offender, witnesses, right? All those folks are protected against retaliation. So if somebody files a complaint against you and you know you've done nothing wrong, then you got nothing to worry about. But if you did do something wrong and somebody files a complaint against you, now you got something to worry about. So let's all just be kind, considerate, respectful. You don't have to like the people you work with. You just have to get along. Be professional at work. Title VII says you have 180 days from the time an incident occurs to file your complaint. 180 days. That's a long time. However, if you're going to file with the EEOC, they've extended that time to 300 days. Don't wait 300 days to file a complaint. Don't wait 180 days to file a complaint. When it happens, you document it. Then you report it. If it happens again, you document it and you report it. If it happens and you document it and it never happens again, great. Nothing lost other than what? 2 minutes to document who, what, when, where, why, and how it made you feel. But if it does happen again, you've got that documentation saying, well, this is the first time and now it's happened again. Okay? So don't wait 180 days. Don't wait 300 days. Document and report it. All right, the next federal law we're going to take a look at is the Equal Pay Act of 1963. This law prohibits discrimination in pay based on gender. You got a man and a woman doing the same job, they should get the same pay. However, the circumstances have to be the same. They would have to have the same education level, the same experience level in order to get equal pay. If the woman has more education, well, that would be justification for higher pay. If the man has more work experience, well, that's justification for higher pay. But if they're relatively the same, then they should get relatively the same pay. We don't have to worry about that here at CTC because we all work off of a pay scale. Now, the Equal Pay Act of 1963 is great, right? It's the theory behind it is awesome. But what if you don't know how much the other person or other people are making? Good coffee. If you don't know, then there's nothing you can do, huh? Right. So you can go ask your coworkers, how much do you get paid? And they may or may not tell you. It's up to them. Some employers, not CTC, but some employers may require you to sign a letter of non-disclosure saying you will not discuss your pay with other employees. I know the job I had before I got to CTC, I had to sign one of those. And it was grounds for termination if they found out that I was discussing my pay with other employees. So I wasn't about to tell these folks how much I was getting paid. And I didn't care how much they were getting paid. I went to work, I did my job, I did what I have to. Okay? So there was a woman who worked for Goodyear. She was a production floor supervisor in their Goodyear plant. She worked there for years and years and years and years. After she retired, she found out she was getting paid less than her male coworkers, her male peers. She said, well, that ain't right. Let me go file a complaint with the EEOC in Washington. The EEOC said, that ain't right. Let's sue Goodyear. So they took Goodyear to court. The judge said, well, that ain't right. Goodyear give her $2 million. Ooh. Goodyear said, don't you spend any of our money because we're going to get it back. Goodyear went to the appeals court with a new set of lawyers. And they said, well, Judge, the law says you have 180 days from the time an incident occurs to file a complaint. She's retired. It's been way more than 180 days since she agreed upon a salary. And that's the incident when we're talking about pay. Goodyear got their money back. The EEOC wasn't happy with that decision. And needless to say, neither was this young lady. Her name is Lily Ledbetter. The EEOC said, Lily, why don't you come to Washington and help us lobby for this Fair Pay Act of 2009? So she went to Washington and she lobbied and lobbied and lobbied, and all her work paid off because in February of 2009, President Obama signed into law the Lily Ledbetter Fair Pay Act of 2009. Yay! So what this law does is essentially, the Reader's Digest condensed version, is it resets that 180 days every time you get paid. Because they figure if you get paid and you don't think you're getting enough, you're going to go ask for a pay raise. That's negotiation. If you're satisfied with your paycheck, then you don't need to go talk to your boss to get a pay raise because you're happy with it. That's negotiation. So they backdated this law 2 years. So Lily got her $2 million plus 2 years back pay. Go Lily. The next law that we're going to take a look at is the Age Discrimination Employment Act of 1967 as amended. This law prohibits discrimination by public and private employers in all personnel decisions because of a person's age. But the kicker with this one is you have to be 40 or older. If you're 39 and you believe you're being discriminated against because of your age, sorry, can't help you there. You must be 40. It's tough to prove if you file a complaint of age discrimination. Right? It's one of the harder ones. Age and color are probably the two hardest categories to prove. Okay? But it can be done. It can be done. Questions? Comments? No? Okay, moving on then. Then we have the Americans with Disabilities Act, the ADA. You may have seen some folks running around campus here doing some construction, redoing some parking places, adjusting handrails in the bathrooms, that kind of stuff. That's to make sure that we are in compliance with the Americans with Disabilities Act, okay? So what this act does is it prohibits discrimination by employers in personnel decisions based on mental or physical disabilities. Mental or physical disabilities. In order to file a complaint under this law, you must meet one of three categories, I guess is a good way to say it. Basically, your impairment must meet the definition of a disability. So number one is that disability limits one or more major life activities. A life activity is an activity that an average person can perform with little or no difficulties. Things like walking and talking and, speaking, that kind of stuff. Stuff that we do every day without really thinking about it, even though we should stop and think sometimes before we speak. Okay, so that's number one, limits one or more major life activities. Number two, the individual has documentation of that impairment. A medical record is essentially what we're looking for here, because not all impairments are always visible, not always detectable, such as epilepsy, cancer, things like that. They may require special equipment or additional time off or doctor's appointments, things of that nature. So if you have a condition and you're going to need more time off, or you're going to need some sort of special equipment, get yourself a note from your doctor. That's your documentation. And then the third possibility of being considered, disabled, I guess you could say, is the individual is regarded as having a disability. So whether you have a disability or not, if you're being treated as if you have a disability, then you can file a complaint under the Americans with Disabilities Act. Okay? So any one of those three. So to go another step with number three is regarded as having. If you have a disability, but you don't want to be treated any differently than other people, but they treat you differently because of your disability, you can file a complaint with the ADA. All right, so that one's kind of two-sided. If you don't have it, but you're treating that way, or if you do have it, but don't want to be treated that way, then there's that individual regarded as having a disability. Okay? All right, so one of the big things about this is the employee must self-disclose. Employers, supervisors, coworkers cannot by law ask you if you have a disability. So if you need some sort of accommodation, or if you believe you're being treated unfairly, then you're going to have to self-disclose that you have a disability. Now, depending on what you're looking to happen, you don't have to disclose to your coworker or to your supervisor what your disability is. Now, if you need some sort of accommodation, which is the next part of this, once it's known that you have a disability, if you need some sort of accommodation, the employer has an affirmative duty to make reasonable workplace accommodations. That does not constitute an undue hardship on the employer. So the degree of reasonability and what makes a hardship usually revolves simply around that big old dollar sign, money. If you need something like a special monitor, a bigger monitor, maybe you need a standing desk or a special chair, something of that nature, bring in a note from your doctor that states what your disability is and what accommodation you need. Go to your supervisor and say, hey, boss, I need some sort of accommodation, because CTC needs to make sure that you have every opportunity to perform at the same level as people without a disability. So they need to provide you what you need to be that person. Okay? We want you to be the best that you can be. So bring in that letter. Go talk to Jackie Thomas. Say, here's my note, my accommodation note. And then they'll get with your supervisor and they'll say, okay, how much money you got in your account? And they'll take whatever they can out of your departmental account, and then CTC, if need be, will throw in any additional money. Okay? But if you need something like an elevator to get to the second floor of a building, no, that's not reasonable. in a situation like that, what the reasonable action would be to move that second floor office down to the first floor. And if that means we have to take somebody from the first floor and move their office upstairs, that's reasonable accommodation. Even if that person downstairs threatens to quit, if they get moved upstairs, you're still going to take that office from upstairs, move it downstairs, move the downstairs office, move it upstairs, because that person who threatens to quit can be replaced. All right. Now, in 2008, President Bush signed the ADAA, the Americans with Disabilities Act, Amendments Act of 2008. What this act did is it expanded the definition of a disability. He said, okay, this is what we consider a disability right now. This is what we're going to consider a disability in the future. And that list can grow and grow and grow and grow. Because it created two non-exhaustive lists. Okay? When it comes to major life activities, there's a whole lot of stuff that can be considered, or a whole lot of things that can impact a major life activity. So the first list includes many of the things that they recognize before: the walking and the talking and the seeing and the hearing, right? The stuff that we do every day without stopping to think about. It's the second list that made the big difference, because it includes major bodily functions, to include normal cell growth, cancer, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. I'm not going to define all of these, so don't ask. Just know that if there's a major bodily function and you've got an issue with that bodily function and it requires you to get some sort of special accommodation, bring in your note with what accommodation you need, and CTC will take care of it to the best of their ability. All right, state laws. Texas laws. Texas is what I call a copycat state. Their laws prohibit employment discrimination. Sound familiar? Yeah, they cover all personnel decisions that could affect equal employment opportunities. Sound familiar? Essentially, Texas laws codify existing federal laws. If a federal law changes, Texas is going to make adjustments so that they meet all the same criteria that the federal laws do. Down in Austin, we have the Texas Workforce Commission. And within that Workforce Commission, we have the Civil Rights Division. The Civil Rights Division are the folks that enforce the Texas Commission on Human Rights Act, the TCHRA. This is essentially the Texas version of Title VII. It prohibits employment discrimination in all personnel decisions based on any of the protected categories under state or federal law. So we need to make sure we apply these standards equally, folks, right? Again, tolerance, acceptance, and understanding. Tolerate different behavior, not bad behavior. Accept others for who they are, not who you think they should be. And seek to understand why they do the things they do. The more you understand about the person, then the easier it'll be to tolerate those different behaviors. Make sense? All right. Well, this is the end of part one. No retaliation against anyone who files a complaint, who may bring issues to your attention. Maybe you did or said something to them. If they come to you and ask you to stop doing it, be the gracious coworker and apologize, and don't ever do it again. Right? And unfortunately, you haven't seen the passkey for the completion form, so you're gonna have to watch the second video, right? The second video, we're gonna talk about sexual harassment, sexual assault, sexual misconduct kind of stuff, okay? So for now, I'm gonna say thanks for being here. Stay safe, stay healthy, and stay happy. And we'll talk to you later.